case do we have, Mr. Johnson?
It's the State of Washington versus Alan Polevia.
Okay.
We have two cause numbers, 131008587 Seattle and 131115430 Seattle. The defendant is present in custody, represented by Nicole Hecklinger. Darren Thompson present for the state. Ms. Hecklinger, is there also a family member present?
That's correct, Your Honor. On behalf of Polevia, his sister Alan Moore is present as well.
Okay. Thanks for being.
And in this case, the defendant pled guilty before Your Honor, actually, on September 5th of this year, in the cause number ending in 430. He pled guilty as charged to count 1, burglary in the second degree. In the cause number ending in 587, he pled guilty to count 1, which is theft in the second degree, and count 2, which is theft in the third degree. As for the maximums here, burglary in the second degree is a Class B felony. The maximum is 10 years and a $20,000 fine. His score for burglary is 2. It's a level 3 offense. His standard range is 4 to 12 months. On the theft in the second degree, this is a Class C felony. The maximum is 5 years and a $10,000 fine. His score is 2. It's a level 1 offense, so his range is 2 to 5 months. And then on the theft in the third degree, it is a gross misdemeanor. The maximum is 364 days and a $5,000 fine. In this case, the state amended the burglary in the second degree pursuant to evidentiary considerations. Upon further investigation, the state determined that it was actually a theft of an item that was worth over $750. It was not actually a burglary, which is what it originally been charged as. So that is the reason for the reduction from burglary in the second degree to theft in the second degree. There was confusion about whether or not this was a building we were talking about. And so the defendant is essentially pleading guilty as charged to the crimes that he committed in these two incidents. So we have the burglary in the second degree, theft in the second degree, and the theft in the third degree.
Okay.
The state's recommendation is for 6 months jail on the burglary in the second degree, 6 months jail on the theft in the third degree, and then 5 months jail on the theft in the second degree, and that's simply because that maxes out at 5 months. So the state's intention is for the defendant to serve 6 months in jail. All of these would be served concurrently. The state has done some research on restitution. There is no restitution in the cause number ending in 587. For the cause number ending in 430, restitution is still being determined. That's the burglary in the second degree. The state would ask leave to set a hearing if needed within the next 6 months regarding restitution. The state is also asking for no contact with the victims or the addresses. That's Richard McElvain, 10003 28th Avenue Southwest in Seattle. Stephen Rhonda Carter, 5014 37th Avenue Southwest in Seattle. Robert Marshall, 5037 36th Avenue Southwest in Seattle. The state also asks for the victim penalty assessment and the DNA fee. I'm happy to answer any questions if the court has any.
I know that this time. Hecklinger?
Thank you, Your Honor. Your Honor, I think that this was an appropriate resolution under the circumstances of these cases. As indicated, I think once Mr. Thompson and I actually looked at the photos from the case that was reduced to the fact, it became clear that that it was not a building, that it was in a yard on a patio, but it was not in a building that this item was taken from, and so that was the more appropriate charge. He was arrested and the property returned, and I believe both cases, but we certainly are willing to give the state time to just double check on the other case as well. I'd be surprised if there was restitution now. And the other case was
they recovered the backpack, didn't they?
Yes.
Yeah.
So I'll be surprised, but again, we'll give the state time to investigate that.
Sure.
As far as this is an agreed recommendation sentencing-wise. His sister, who's present, is a social worker, works at YWCA. She and I actually talked quite a bit about family history, and she has been talking a lot to her brother. The plan is that when he is done with his sentence, that he has a place to live with her, that he's working with the jail release planners on social services to help support him in staying out of trouble. There's no community custody standard on these types of cases, but fortunately he has a family member who has social service background and jail release services support as well. to obtain any additional needed services when he's released. We're asking the court to follow the agreed recommendation in these cases.
All right. Mr. Polevia? Polevia? Sorry, Polevia. Good afternoon.
Good afternoon. How you doing today?
Okay, good to see you again, although I wish it wasn't in these circumstances. So, anything you'd like to tell me today, sir?
I hope you follow the recommendations. I think I learned my lesson this time. Got a lot of time to think about things, you know. I need to get out there and make a couple things right for my family and my kids, you know. It's my daughter's birthday, October 6th, you know, so I'm going to miss that. So I've been messing up the last couple of years, you know. I've been going through some stuff, and I had some time to think about it, you know.
When you say stuff, are you talking about
Well,
drug use?
It's a long story, guys. I was with my baby's mom for 16 years, and we went through some things. She left me for somebody else. You know, I took to getting high, you know, messing up. You know, I talked to her, you know, she wants, you know, get me back in the kids' lives, you know. And, you know, so, I mean, I'm just trying to make it right, you know. My favorite thing in the world is to be a father, you know what I mean? So, I'm trying to do it.
Okay. Well, and I was reading through the police reports on this, and something kind of struck me about it. You told the officer that you'd just been released from jail recently, and that you came home, and the person that you were living with was about to do heroin, and so you decided to leave. And I thought, good for you, good decision. But then you also told the officer that you had just smoked out the night before.
Yeah.
I thought, so close to making two really good decisions. Have drugs ever been a good part of your life?
No, not at all. Not at all. You know, drug use has been a problem in my family for a long time, since I was little, you know. It's been rough, you know. What really saved me from using drugs was my children, you know. And I lost them to a terrible situation with my baby's mom.
It sounds like you might have them back in your life a little bit more.
Yeah, I'm ready to get to it, you know, get back to work. I want to raise my kids right, you know. I don't want them growing up like I did, you know. So that's my goal now. You know? It was my goal before, but I got lost, you know.
Well, I'm glad you're going to be staying with someone like your sister that doesn't get herself involved in those things, and is going to provide a much better environment for you to be in.
Yeah, she's my heart. She's good people.
Yeah.
She stands by me, you know, when nobody else does. So yeah.
Okay.
I'm happy to have her too.
All right. But you know she's even got limits, right?
Yeah, no doubt.
So she expects you not to be doing those drugs, just like I expect you not to be doing those drugs.
Definitely.
And your kids don't want you doing that.
Yes, sir.
All right. Sounds like we're all on the same page about what we want for your life.
Definitely.
The hard part is doing it, right?
Yes, sir.
Okay. Anything else from the other parties?
Your Honor, the only thing that I think we didn't cover was this parties are coming to an agreement that the defendant has credit for 95 days on
Okay.
both of these cause numbers, so we would be writing that in on the judgment and sentences.
And I don't have a problem doing that, but I've found that the folks that are actually in charge of making that calculation at the Department of Corrections don't always adopt what we say.
Well, he won't be going to the Department of
Because it's
Corrections.
for 12 months.
Right,
I mean,
it's
it's
under
6
12
months.
months,
6
yeah.
months. So,
Right.
okay.
The problem is that what happened was after he, like you said, he was out of custody and he was booked. He never got remanded. Even though I remember at the time when we asked him to be remanded, it looks like they never got him remanded on it. So it only shows 4 days of credit
Okay.
on the other one. And Mr. Thompson and I had been discussing the whole time that he should get credit for those days.
All right. Sounds like the state's on board with that.
Yes, I had
Yeah.
assumed that he was remanded, and we thought he was in on both of them, but he wasn't.
Yeah.
All right. I don't have a problem with that.
Thank you.
Okay. Anything else from any of the parties?
No, thank you.
Okay. Well, it's a very good sign that your sister is here, that she's supporting you, that she's going to provide you with a clean place to live. And by clean, I mean that in every sense. And that you're going to stop having drugs to be a part of your life. Because nothing good has happened. And that's been what you've been doing. And you've got too much to live for. You've got too many other people that are depending on you. All right? So, Having considered your criminal history, having considered the facts of this case, having heard from you, your attorney, and from the state, the court is going to exercise this discretion by adopting the agreed recommendation as my own. 6 months in the case ending in 43-0. 6 months for count 1 in the case ending 58-7, and 5 months in, for count 2 in that same case number. And while it wasn't part of the party's specific discussions, I'm going to impose no illegal, non-prescribed drugs. Don't take drugs. They're not a good part of your life. You've said it. You know that. So I'm just going to include that as a condition, okay? Does that make sense to you?
Thank you.
All right. And $500 victim penalty assessment and $100 DNA fee. I'm going to waive all waivable fines and fees. You've got appointed counsel and you're unemployed at this time. I want you spending what money you have to help support your children and to pay back any of the victims in this case. Although it sounds like I think restitution is not going to be an issue. It sounds like most of the property, if not all of it, is recovered, but I'm happy to give the state a chance to reserve that and present anything that needs to be. Secondly, did you have a chance to talk to your client about whether or not you want to waive his presence at any restitution hearing?
Let me just double check, Your Honor.
Sure.
So, is there a possibility that they could pursue the restitution request in time in the 1800 case? I can handle it for you. And you can get your presence, and you can just check with me. Your Honor, do it waive his presence.
All right.
Your Honor, one thing that I'm assuming the court meant to say, the court is doing concurrent sentences on
Oh,
everything,
yes.
assuming.
I appreciate you asking, but definitely.
And
That
is-
was part of the agreed recommendation.
And is the court also covering the no contacts that the state was requesting?
And I didn't get all the addresses. I know that they're in the investigation reports, and so those addresses and then no contact from any of the victims in this matter. So happy to include that as part of the sentence.
Take just a moment, we have three
Sure.
separate judgment sentences here.
And I want to make sure,
And this is the notice of rights and appeal. What this means is that because you get pled guilty, and because remember that you don't have right to appeal when you plead guilty, you have to you're not comfortable. But even if you plead guilty, you have your rights to the collateral attack, as described in Minutes 6 and 7. Most of those are within 1 year. Some are any time. So you can look at these if you have any questions. Please feel free to call me, or you look up the laws, or any, or pop another one. If somebody's signing, you can your signature.
so it sounds like he's gone over and is acknowledging receipt of his rights of appeal.
Yes, Your Honor.
I also need to make sure you understand, Mr. Polevia, that you have lost your right to possess a firearm. You also lost your right to vote. Both of those rights can be restored to you by a court of law, but until those rights have been restored, you do not have either the right to possess a firearm or to vote.
Is there a certain time limit?
You can talk to Ms. Hecklinger about what kind of time limit would apply in this matter, or to this case. And I'm not sure if your rights have been restored in any other convictions that you've had. So you'd also want to double check if you're eligible under those cost numbers.
The voting rights are fairly simple. The other ones are very complex and may sometimes also include having to check whether or not federal rights have been revoked. I'd have to do some research to give you more information beyond that. Just some pieces of work the other case.
Mr. Polevia, I want to make sure you understand, I have included in the sentence the no contact order that was worked out and agreed to by the parties here. So you can't go back to those addresses and you can't have contact with any other victims in this matter, okay?
And then each of these cases have a signature page that gets attached to them. That's your signature, Gina, your sister's address. So I have your signature on these, and then I'll do your fingerprints. And it's for your signatures there. See if I can get your sister's. She's what I can start getting to. So then I'm having you fingerprints, I can show these. Fingerprints, release. So you need the whole fingerprint, not just the fingertips, okay? So when you're ready to look invisible, is it do your fingers at an angle like this? Press down, press on that, lift right up, don't roll like this, okay? And then re-ink into the other one, okay? And then some happens for your work, okay? Yeah, great.
Regarding the court's order regarding the defendant avoiding drugs, is the court also ordering that he avoid alcohol?
I didn't see anything in the police reports indicating that he has an issue with that. Obviously, he knows not to replace one vice with another, but it doesn't sound like that's been a problem in his life, so I hadn't planned on including that in the sentence.
I will cross that out. I checked out habit.
Sure.
How does it get better? Okay. Okay.
The second one, have you had a chance to review the judgment sentence?
I have reviewed the one that I passed up, and I believe it is accurate, Your Honor.
Okay, I know there's going to be,
Two more coming.
oh, I hope I said it, but if I didn't, I am giving you credit for that time served for 95 days.
The other felony one I reviewed, and then finally.
And for the record, I know the court's already gone over it, but the defendant has signed his notice of rights on appeal for both clause numbers, as well as his notice of loss of right to vote and his loss of firearm rights. He's receiving copies of those, and he'll receive copies of the judgment and sentence before he leaves.
I've reviewed all the judgment and sentences and signed it now.
All right, thanks.
I believe that concludes the matter. We'll take copies for the defendant.
Okay.